an opportunity, not an afterthought. The prosecution of stalking, which is conduct now covered under the Violence Against Women Act 2022 Special Tribal Criminal Jurisdiction, today will be discussed by Jonathan Kurland, an attorney advisor with Aequitas, and Natalie Ivey from the Stalking Prevention Awareness and Resource Center. With that, I'm going to turn it over briefly to my colleague, Kelly Gainstoner from the Tribal Law and Policy Institute, and we'll get started. Thank you.
Thanks, Chia, and welcome everyone to our second webinar on stalking. If you missed the first webinar, which really addressed the basics of identifying stalking and had a very interesting piece in it about critical thinking as we all work with victims of stalking, Marlon might be able to drop that in the chat. From time to time, we'll be putting things in the chat for you. Just a little context for how we got to where we are today. TLPI is a national technical assistance provider to the ITWIG. And for those of you who don't know what the ITWIG is, it stands for the Intertribal Working Group. And it's been, TLPI has been with the group of tribes that are either implementing VAWA 2022 criminal jurisdiction over non-Indians or planning or thinking about implementing VAWA 2022. And the ITWIG held its last meeting a few weeks ago. And during the meeting of all of these folks that work in Indian country towards implementing VAWA 2022, it came to our attention that the ITWIG wanted more information on this crime of stalking. So the first series really was the basic. This one, very interested to follow John as he delves into the actual charge of stalking. But before we get started on that, I just want to give you the briefest summation about VAWA 2022. It is a jurisdictional statute, and you will find it in federal law under the Indian Civil Rights Act. And one of the 9 covered crimes of VAWA 2022 is stalking. So in a nutshell, Congress recognizes tribal inherent authority to prosecute non-Indians who commit one of these 9 covered crimes. Again, focusing on stalking today. Since VAWA 2022 is a jurisdictional statute, tribes will look to their own stalking statutes and their own tribal codes for prosecuting these cases. So there are a few resources that I just wanted to bring to your attention before we move on in, since we will not be focusing on special tribal criminal jurisdiction of VAWA 2022 today. We're going into a much broader general presentation. I wanted to point your attention, and hopefully Marlon will put these in the chat. I can't see the chat right at this moment. TLPI, Tribal Law and Policy Institute, has a comprehensive VAWA 2022 website. You can get a lot more information there. And when VAWA 2022 first came out, TLPI did extensive webinars and had extensive conversations online with folks about all of the covered crimes. And so Marlon can link you to the webinar and conversation on stalking, and that might be helpful to you. Also, let me see what else I wanted to tell you today. There is also a TLPI publication that's relevant, although not updated, for VAWA 2022. For those of you in the audience who might be considering amending or drafting a stalking code, and Marlon will put that in the chat as well. These are all free for download. And so with that, I would like to turn this over to the experts today, SPARC and Aequitas. John?
Kelly, thank you so much for the introduction. Marlon and Chia, thank you so much for organizing this, and thank you to TLPI for inviting me and Aequitas as well as SPARC for the opportunity to talk about stalking. As Kelly already sort of set the table, I'm part 2 of this stalking presentation. My incredibly talented colleague, Natalie Ivey, she was part 1 2 weeks ago, where she sort of talked about an overview about how to identify and recognizing stalking and stalking behaviors. What my goal is today is to talk about stalking charges from a prosecutorial perspective, which means sort of appreciating how stalking charges are legalistically constructed, but also trying to get an appreciation for how stalking can be used as a litigation tool in prosecutions, as a device in which to be victim-centered as well as holding offenders accountable. So with that, before I get into that substance, I do want to give a little bit of a background about who I'm with, Aequitas. Now, hopefully everyone here has already heard of Aequitas before I joined, but I'm not going to proceed on that assumption. I want to give you a little bit of background about what we do. Aequitas is essentially a sister organization to SPARC, the organization my colleague Natalie Ivey is working with when she spoke with you 2 weeks ago. Aequitas, we're a nonprofit with a brick and mortar based in Washington, D.C. And what our mission is to try to learn about, develop, and also train on best practices in the areas of sexual violence, intimate partner violence, stalking, and human trafficking. We're primarily made up of attorney advisors like myself who were prosecutors in local jurisdictions that specialized in these different areas. Now, how do we try to execute our mission? Well, one is you're seeing the proof in the pudding, so to speak, with what I'm doing today. We conduct training events. These can be virtual training events. If you're interested, you can find a bunch of them archived on our YouTube channel. But they're also they're also in-person training events that are conducted nationally and sometimes internationally as well. We also have a variety of resources that we develop. The nature of these resources can be strategy guides on different topics relevant to sexual violence, intimate partner violence, stalking, and human trafficking. It can be in the nature of statutory compilations, case law compilations, things of that nature. We're also available for consultations. The nature of these consultations, they could be really case-specific types of things. Like, wow, Kurland, I really loved the conversation we had on July 25th, I think that's today's date, about stalking. I've got a case right now where I have an offender that committed a couple instances of conduct within tribal territory, but there are also some instances of conduct that were outside tribal. Can you help me? Can we brainstorm about ways I can bring that in so that it can be encompassed? But these consultations can also be a little broader base than just a case-specific issue or challenge that you're confronting. They can be in the nature of, wow, we really want to sort of ramp up our multidisciplinary process. Can you talk to us or brainstorm with the ways about other jurisdictions we're able to develop buy-in from all the stakeholders, from prosecutors, from law enforcement, from community, system-based advocates, or what have you? Aequitas is able to have the luxury of benefiting a lot of partnerships with other national technical assistance providers. So what this means is that even when we institutionally or collectively might not have an answer for you, we can always call on a nationwide network of experts to get you an answer to any issue that you have in your case. Just like with SPARC that I'm sure Natalie told you about a couple weeks ago, you can also follow us on the different social medias. You want to get updated about different trainings we're offering, different resources we develop. While a lot of it is sort of targeted towards prosecutors, it won't be of interest just to prosecutors. Certainly if you're coming from an investigation background, an advocacy background, medical provider, community support, what have you, I think you're going to find something interesting that we develop. You can also check out all that we offer on our website, equitasresource.org, which is laid out right here, and I concede is not really intuitively spelled. Here's a user hack for those of you that are interested. If you go to our website, hopefully not during this webinar, scroll down to the footer, enter your work or organizational email address. You can also get put on our email blast where you can get updated about new things we offer and develop. New things that our allied national technical assistance providers might be doing. You can also get notified about maybe grant opportunities that might be of interest or available for your communities. I do want to give reference because we're talking about stalking and I'm actually under sort of the SPARC umbrella as I speak to you today. stalkingawareness.org. That's the website for our sister organization at SPARC. And they just have an incredible volume of resources that I'm constantly referring to and using in my work when I'm developing this sort of content. So housekeeping matter I have to present right now is how we're funded is through grants, in this case, by the Office of Violence Against Women out of the Department of Justice. We are really grateful for that support because it allows our work to be available on as wide a basis as possible. This also means that the time spent for this training is at no cost to TLPI. The resources you can download from our website that I reference, you can do so for free. And if you reach out to us for consultations, that's totally free as well. However, the caveat I do have to give is that hopefully nothing I say today will be found to be offensive or disagreeable. But in the event it does, you should know that it doesn't necessarily reflect the views of the Department of Justice generally, or the Office on Violence Against Women specifically. So, hey, here's a picture of me, and I do want to give you a little bit of my background. I've worked as an attorney advisor with Aequitas for about 7.5 years, specializing mostly in crimes involving stalking, intimate partner violence, and sexual violence. I've gotten to do some work with tribal jurisdictions through training at National Institutes on Prosecutions of Domestic Violence and an Institute on the Prosecution of Sexual Violence. It was held out of the National Advocacy Center in Columbia, South Carolina, as well as also working on various consultations involving tribal country. I don't originally come from a jurisdiction, though, to be candid, where there is a lot of sort of interaction or opportunity to develop expertise or knowledge about the issues unique to tribal jurisdictions. Where I came from before I joined Aequitas was I worked as a prosecutor for about 20 years in Pennsylvania, primarily in the jurisdiction of Berks County, Pennsylvania. Now, if you're not familiar with Pennsylvania geography, you shouldn't be faulted for that. But just to give you some reference, Berks County is primarily known for the city of Reading and really the best snack pretzels in anywhere in the United States. So if you're a fan of pretzels, you should be a fan of Berks County. But when I was a prosecutor in Berks County, I started off as a line prosecutor, a line ADA, and did a lot of different sort of specialized tasks. But really what my focus ended up being was crimes involving the most vulnerable of victims, especially child abuse, intimate partner violence, sexual violence, and homicide. I stayed there for quite a bit till I joined Aequitas in 2017. And what's great about Aequitas is I really get to sort of observe and understand practice in different areas of the country and understand challenges that were similar and contrasting to what I dealt with in Aequitas as I worked with fellow prosecutors, advocates, and law enforcement. So there's a fair use notice. I'm not going to really dive much deeper into that other than to reference it. And finally, I'm going to be getting into the substance of our presentation today as we're here for the next 75 minutes or so. So what we're going to be trying to do today is we're going to be trying to identify stalking offenses and dynamics, how stalking statutes are and can be constructed, especially under Title 25 of the U.S. Code. Once we do that, we want to talk about ways we can enhance the investigation and prosecution of stalking, both as a standalone offense and recognizing it as a co-occurring offense, especially to dynamics involving intimate partner violence and sexual violence, and understanding stalking and charging stalking as a way and an instrument in which we can increase the safety of stalking victims, or I should just say victims, really. So let me begin with a conversation about charging stalking, or how a stalking charge is constructed. And hopefully this isn't going to be too redundant or overlapping with what Natalie talked about, that it's going to be different enough to be interesting. But to start off with that conversation, I want to really open up the comments about sort of a criminal law 101 review. And that's how any crime is going to be constructed. Any crime or any crime codified into a law or to a statute can be broken down into various components or parts. For those of you who remember from grammar school days, it's almost can be similar to diagramming a sentence into like subject and verb and predicate and direct object and things of that nature. Really, the fundamental component of any kind of criminal violation, anything that's going to be codified or articulated as a crime by a set of laws or by a code of laws is going to be a criminal act. Every crime has to have at least an act. You can't make a crime for just someone thinking something bad or thinking something naughty. For something to be a violation, there has to be at least an act. Now, the nature of this act, it can be general intent or specific intent. And for those of you who went to law school, this might be causing some flashbacks as you sort of think about the distinctions. But broadly speaking, what a general intent act is, you intend the physical action. A specific intent is you intend the result of that action. So for instance, let me just take the crime of theft. The act of theft, when it's specific, when it's a general intent statute, is that you intend to take a piece of property. You, using your volition, using your nervous system, you command your body to take a piece of property. Burglary, however, in contrast, is usually going to be a specific intent crime, because what burglary is usually is that you violate someone's property, you enter someone's property with an intent to commit a crime inside. So for the act of burglary is that when you enter someone, it has to be with the conscious desire that you're going to be committing a crime inside, whether it's to hurt someone, whether it's to steal something, or some other kind of crime. But crimes can have other kinds of elements in addition to the act. And in reality, when you think about it, most crimes only make sense is when the act is joined with some other element. The nature of this sort of other element that can be joining a criminal act is going to be the mental state or an attendant circumstance. Let me talk about the attendant circumstance, because I think that's sort of easier to communicate or understand. An attendant circumstance is some condition that can make a particular act a crime. So again, without trying to go blue or too graphic or explicit here, I think probably one of the easiest ways to illustrate an attendant circumstance is going to be an act of child sexual abuse. What the criminal act in most offenses involving child sexual abuse is an act of sexual contact. Whatever the nature of that sexual contact is, whether it's penetration of genitals or whatever. What makes that a crime, because a lot of human beings on the planet have sexual contact, but what makes it a crime or the attendant circumstance is the circumstance that the person you're having the sexual contact with is under a certain age, whether it's under 16 years of age, under 12 years of age, or under 13 years of age. So the age of the victim would be an attendant circumstance. The other kind of element that can be used to make up a crime is some kind of requirement of an accompanying mental state, whether that mental state when you commit the act is purposeful, whether it's knowing, or whether it's reckless. And down the road, I'm going to sort of define more specifically what purposeful, knowing, and reckless can mean as terms of art. But for purpose of our conversation right now let's go back to that example of theft. We already discussed, like, if you commit a crime of theft, the act is taking a piece of property. Well, the mental state that could make that taking a piece of property a crime is that you're intending or recklessly intending that when you take that piece of property, you're intending to deprive or take away another person's ownership rights in that piece of property. And you might say the attendant circumstance is that the property you're taking is not yours to begin with. So there you have sort of different elements, and hopefully that'll give you a good illustration of these general sort of different kinds of elements. So we're going to talk about how this applies to stalking, but let me proceed to about the definition of stalking we're working under, especially here under Title 25 of the U.S. Code. Here, the term stalking means engaging in a course of conduct directed at a specific person prescribed by the criminal law of the Indian tribe that has jurisdiction over the Indian country where the violation occurs, and that would cause a reasonable person to fear for the person's safety or the safety of others, or to suffer substantial emotional distress. So this is essentially the baseline or floor that we're working for what can be a stalking violation in under a tribal jurisdiction. The difficulty is that under Title 25, even though this statute contains lots of words that are sort of statutory terms of art, it doesn't really define those terms of art. So how do we understand or orient ourselves to what they mean? Well, that course of conduct, to sort of get a working definition, one of the things I think we can look to is Title 18, the Crimes Code under the U.S. Code, where they define what course of conduct means in reference to a Title 18 definition of stalking. And there, the course of conduct is defined as a pattern of conduct composed of two or more acts evidencing a continuity of purpose. Now, look, Title 18, I'm not saying that this has jurisdiction or precedential authority over Title 25, but if you're looking about how to define this course of conduct under Title 25, that Title 18 is a pretty good reference because one, well, why would they define course of conduct one way in Title 18, but differently in Title 25? So that's a good argument that course of conduct in Title 25 should be viewed to mean two or more acts. The other reason why they probably consider course of conduct to be just two or more acts in Title 25 is because this is usually how course of conduct is defined in most areas of the country that have a stalking crime or an element of course of conduct. There are exceptions to the rule. For those of you looking to win trivia night, Massachusetts actually requires 3 or more acts. There's a few more others that require 3 or more acts. But most jurisdictions, when they're defining course of conduct or repeated acts, what they mean is 2 or more acts. What this means and why it's so helpful in terms of definition is that stalking, if you only need 2 or more acts evidencing a continuity of purpose, the threshold for meeting stalking can be kind of low. One way I'd recommend you could conceptually think about it is that when there's an incident of domestic violence, there's a call to dispatch or 911 or emergency, and investigation or law enforcement or constables respond to that, is that you can think of that if stalking only needs 2 or more acts, that incident of assault or abuse is 1 act. In some ways, you might think every instance of domestic violence can be 50% of a stalking case. Every instance of sexual violence is 50% of a stalking act. If the investigation or evidence can be uncovered of at least 1 more act at a different time against this victim, you could have stalking. All right, so I spent some time, you remember, back at the beginning talking about the different parts of a criminal violation, criminal act, attendant circumstance, and a mental state. How does this apply to Title 25's definition of stalking? Or how can we sort of break down this definition of stalking to these different elements? Well, the course of the criminal act, in Title 25 stalking violation, the criminal act is going to be that engaging in a course of conduct directed at a specific person. So that's the act that an offender has to commit to at least complete one element of the crime of stalking. Then to complete the crime of stalking, there's 2 alternate attendant circumstances that can happen. So this is an either or situation. You need a criminal act and this attendant circumstance number 1, or this attendant circumstance number 2. The attendant circumstance number 1 would be a course of conduct directed at a specific person that would cause a reasonable person to fear for their safety or the safety of others. Alternatively, you could have someone engaging in a course of conduct directed at a specific person that would cause a reasonable person to suffer substantial emotional distress. Now, usually most violations of stalking in reality and in practical circumstances, it's going to have a lot more than just 2 instances of conduct. And you're probably going to have instances of conduct that can concurrently put someone in fear for their safety and cause substantial emotional distress. You might have some instances of conduct that are just intended to cause substantial emotional distress, while others are just going to cause personal safety. but most courses of conduct for stalking is going to be a variety of instances of conduct that's going to be either simultaneously doing these things or causing at least one of these things. And the thing is, usually with stalking, though, we're charging it as sort of in a big umbrella crime as a thread tying together a sort of course of conduct or course of activity that an offender is going to be perpetrating against a particular victim. So that's sort of the down and low or quick and dirty distillation of how a stalking violation can work as a floor, as a minimum, in tribal jurisdiction. But I think I do need to have some conversation about a recent Supreme Court case called Counterman v. Colorado. I'm not sure if folks have heard about Counterman v. Colorado. I know it got some sort of media attention, but I think having an understanding about how that's going to inform a construction of a stalking charge can be pretty helpful. And actually, by having an understanding of Counterman v. Colorado, we can construct stalking statutes in a way that's going to be really belt and suspenders. So before I get into what happened in Counterman v. Colorado, let me give you a little bit of the background. That happened in Colorado, as you probably already guessed. And what happened was a defendant was convicted of stalking in Colorado for communicating hundreds of messages from various social media accounts to the victim, an aspiring singer. And just as for additional background, those social media accounts were anonymous. It was hard to tell from the face of them who the owner or who the sender was, or that Counterman was the author. It took a more in-depth investigation to figure that out. The victim here, the aspiring singer, she had no knowledge of Counterman, didn't know him at all before this happened. He just she just got on his radar, and he started sending a variety of messages. At court or trial, it's agreed, everyone agreed, that Colorado proved that the messages were unwanted and that they would make a reasonable person feel afraid and threatened. And I'm going to give you a sort of a overview of a selection of messages. I think there were a lot more, as I recall. I'm trying to remember whether it was over 50 messages or over 100 messages. But there are a lot more messages than the selection you just see on the screen. But these were the messages that the victim was receiving from Counterman, who was a total stranger to her. In fact, he wasn't even someone that she would be able to identify because she never met him in person, or at least didn't know she ever meeting him in person. But the kind of messages she was receiving was that you in the white Jeep? And the victim, I believe, had a white Jeep. 5 years on Facebook, only a couple physical sightings. I've tapped phone lines before. What do you fear? An image of a stylized text, which I guess means interesting font. I'm currently unsupervised. I know it freaks me out too, but the possibilities are endless. You're not being good for human relations. Die. Don't need you. Talking to others about me isn't pro-life sustaining for my benefit. Cut me a break already. Staying in cyber life is going to kill you. Come out for coffee. You have my number. These messages were not all sent from the same account. These messages were sent from various accounts, even after Counterman was told electronically or through social media to leave me alone, to quit bothering the victim. Counterman kept it up and sent these. And in addition, just to an obvious kind of creep factor, these are pretty scary because you don't know who's going to be hurting you. So these statutes were prosecuted under Colorado stalking statute. And here's what Colorado's stalking statute said. A person commits stalking if the person makes any form of communication with another person in a manner that would cause a reasonable person to suffer serious emotional distress and does cause that person to suffer emotional distress. So while definitely the phrasing is different, this is pretty similarly constructed to how the stalking violation is constructed in Title 25, especially insofar as this construction in Colorado doesn't require proving any kind of mental state or mens rea on the offender, just like a stalking violation under Title 25 doesn't require any kind of mental state or mens rea on the part of the offender. Colorado statute requires proving a criminal act, actually, no, I don't think they've changed it since the statute. A person commits stalking if the person makes any form of communication with another person. That's the act the offender has to complete. And the attendant circumstance number one is in a manner that would cause a reasonable person to suffer emotional distress. The victim did, and a reasonable person would have suffered emotional distress and does cause that person to suffer emotional distress. So while there are some differences and nuances between this and a stalking violation under Title 25, what I really want to stress now is what's similar and what the Colorado statute and what stalking violation under Title 25 have in common is there's no mental state or mens rea required to be proven. And that lack of a requirement for a mental state to be proven was sort of the hook that Counterman, or I should say Counterman's defense attorneys, brought to the Supreme Court, arguing why this wasn't a valid conviction. So what did Counterman say, or what was their argument? As we pointed out, they stressed on Colorado stalking statute, like Title 25. They didn't say that. That's just me pointing that out. Does not require a showing of a mental state or mens rea. Without a showing of a mental state or mens rea for making a communication, for speaking something, they argued the statute was unconstitutional because it could chill communications or speech protected by the First Amendment. Essentially what they're saying is, hey, look, if I can be if basically my speech can be criminalized, in other words, if I make communications to another person that could cause them emotional distress and would cause them emotional distress, then my speech, I could be chilled from sort of producing speech that would be protected under the First Amendment. Colorado argued that, hey, look, the stalking stat criminalized true threats, and true threats aren't protected by the First Amendment, which was correct as a matter of law. But what they said is, look, if you're going to show that the communication was true threats, then you had to prove that Counterman intentionally was intending the communication to be threatening. And the statute didn't require you to prove Counterman's intent because it didn't require any mental state. So what Counterman was arguing is, hey, look, Colorado didn't have to prove that they intended it to be threatening. So essentially, Colorado's stalking statute was so broad, it could chill speech if you're criticizing a public figure or a politician or something of that nature. So let's go through how the court decided, and part of this is a little bit tour of the First Amendment. Now, in giving this tour and having this conversation, I am not an expert in tribal law, and I'm not going to purport to be. So my understanding from some conversations and beginning in preparation for this, the application of whether or not the First Amendment or other portions of the Bill of Rights, how or to what degree it's incorporated in tribal jurisdictions is gray, to say the least. So I'm not trying to say categorically this would or wouldn't be applicable to tribal jurisdictions. But at the end of this Counterman discussion, what I'm going to sort of suggest to you, or hopefully be able to illustrate, is proving a mental state by a stalking offender is going to be not that hard to do. And if you want to take a belt and suspenders approach to making sure your stalking statutes are going to be really bulletproof against litigation, it's probably a good idea to, it's probably safer to have them include a mental state or mens rea element. But I want to sort of take you through how the Supreme Court ruled in Counterman, so you can understand any potential vulnerabilities that might exist for a stalking statute that doesn't have that protection, appreciating and recognizing that the applicability of the incorporation of a lot of stuff in the Bill of Rights to tribal jurisdictions, it's, from my understanding, it's not a black and white matter, that there's some gray involved. All right, so we'll begin with the language in the First Amendment. Congress shall make no law abridging the freedom of speech. Now, there's lots more in the First Amendment. It doesn't just say that, but that's really the relevant part that we need for our conversation and understanding the decision in Counterman v. Colorado. Now, recognizing that broad protection, that presumptive protection for speech, basically, through a series of court cases, there's been a certain variety and animals of speech that have been recognized not to be protected by First Amendment. The first one is going to be true threats, if someone is making a true threat, and we'll get into that definition. And just as a way to sort of give contrast or context, other kinds of speech not protected by the First Amendment is going to be incitement, libel and defamation, obscenity, and fighting words. Now, incitement, that's not protected by the First Amendment. What is that? It's going to be statements directed at producing imminent, which means immediate, lawless actions, and the words have to be intended to produce imminent disorder. This is going to be really hard to prove because a lot of times this something that's going to be alleged or is on the borderline with incitement is going to intersect with political speech, which is what the First Amendment is designed to protect. And if a speaker is sort of giving caveats in his speech as, hey, you should do this peacefully, or I don't want you to break the law, or I don't think anyone should get hurt, but let them know you mean it. Generally, that's not something that's going to be considered legally to be falling into incitement. So it would be speech protected by the First Amendment. A careful speaker can easily avoid speech that might be inflammatory, but doesn't cross the threshold into incitement and not protected by the First Amendment. The other kind of speech not protected by the First Amendment is defamation and libel. Defamation is going to be something spoken. Libel is something written. And what defamation and libel means, it's going to be false statements in the case of defamation, or false writings in the case of libel that harm another person's reputation or that harm someone's reputation. If someone is a public figure, and there's a bunch of legal tests about whether or not someone's a public figure is going to be harmed by a statement that's false, what has to be shown when they're suing someone for that false statement and the harm to reputation is that the speaker or the writer knew it was false or was reckless as to whether it was false. And the reason why you have that threshold, like if a public figure is harmed by something false, they have to show that the speaker or writer intended it to be false or was reckless as to whether it was false, because the court wants to prevent people being chilled from legitimate speech in an effort to avoid being sued. And if you're a public figure and in the public arena, we should have a conversation about what ideas you're presenting and representing, which is why it's going to be harder to claim speech was defamatory or libelous. However, if you're a private figure and you're harmed by false statements, you don't have to show whether the speaker or writer knew it was false or was reckless of whether it was false. You just have to show that the statement about you was false. So if John Q. Public, who really doesn't have a big social media following, not on the news or anything like that, if a false statement were made about John Q. Public, if a statement were made about John Q. Public and John Q. Public wants to sue for that, John Q. just has to show that the statement was false. The other kind of speech not protected by the First Amendment is obscenity. And this is one justice defined this as you know it when you see it. By its nature, it's kind of hard to define because this can also intersect with images and things that might be of research value, scientific value, or artistic value. But other times it can just be purely prurient or just meant to appeal to something more base. But this is described as or defined as valueless material appealing to sexual prurient interest and describing sexual conduct in an offensive way. In other words, the offender, the speaker, must be aware of the nature of the material. In other words, what it's shown does not have to know it was obscene. So I suppose a sort of elementary or really basic example is the offender, if someone is being charged with violating obscenity, if they don't know they're carrying a crate full of dirty magazines, then it can be. If they know they're carrying a crate full of dirty magazines, but they don't consider it obscene, that's not going to be a defense. All right. So the other kind of speech that's not protected by another kind of speech not protected by this First Amendment is fighting words. And this is something like personally abusive epithets or things that are said that are inherently likely to provoke violent reaction. In other words, you're saying something that's intended to set someone off. So this is one area that's not protected, but sort of in our modern age, this is more theoretical rather than actual, because fighting words restrictions on speech, they haven't been upheld in 80 years. So it's really hard to think of a practical example of fighting words that aren't of a fighting words that's not under the protection of the First Amendment. Which brings us to the kind of speech at issue here in Counterman and implicated by most stalking violations, which is true threats. What is true threats? The true part of the definition, it precludes hyperbole, jokes, or anything that does not convey the possibility of coming violence. And essentially, it subjects the listener, the threat part, it subjects the listener or the victim to fear of violence and many kind of disruption that fear engenders. So you might jokingly joke with a friend about something that's going to happen. Oh man, if you're late for work one more day, I'm going to kick your butt, and be sort of laughing or sarcastic when you say that, because it's hopefully the context makes clear it's hyperbole, it's an exaggeration, it's a joke. That's not going to be the definition of true threats, or wouldn't meet the definition of true threat, and thus not under that protection or shield of the First Amendment. But it could also be, the other requirement is it's going to be subjecting a listener to fear, violence, and many kinds of disruption. Now, Counterman, even if not all the statements were explicitly threatening, a lot of those statements, like, hey, I saw you in the white Jeep other day, it would subject the listener to a fear of violence and sort of the rearrangement of life that the disruption, that disruption with that fear would cause and ensue. And that certainly happened with Counterman's victim. She quit performing, her career, her livelihood, quit driving around because she never knew when Counterman was going to pop up and carry through on the threats that were happening. So what did the Counterman court do? How they decide the case? They sort of, I don't want to say split the baby, but they did find a compromise between the two sides, between what Colorado wanted and what the Counterman defense lawyers wanted. The Counterman court said, look, the communications at issue that Counterman had sent, it fit the definition of true threats. And the Supreme Court reiterated that true threats are not protected by the First Amendment. However, they said, for a true threat to be punishable as a criminal violation, there has to be proof that the defendant had at least some sort of personal or subjective understanding that the communications were going to be received as threatening or deemed threatening. In other words, there had to be some sort of proof or evidence of an intent, of a mental state or mens rea of recklessness. So the Supreme Court didn't go to the Counterman position, which was that there had to be proof that the speaker, Counterman in this case, intended them to be threatening. But what they didn't also go as far as Colorado, because they did say, hey, look, you at least have to show that the offender knew, or the speaker knew or should have known that some kind of communication would be taken or received as threatening. So if you're interested in the mechanics of how this broke down, what happened, this meant in Counterman, because there was no evidence as to what Counterman's mental state was. There was no finding of what his mental state was, I should say, because there was evidence of what his mental state was, but just the jury, the nature of Colorado statute precluded a jury from making a finding on what his mental state was. This resulted in Counterman's conviction being reversed and remanded or sent back down, because there was no finding from the record or from the verdict that 12 people agreed that he acted at least recklessly as to the threatening nature of his communications to the victim. In other words, there had to be some sort of finding, and there wasn't any finding. The Counterman consciously disregarded a substantial risk that his communication would be viewed as threatening violence. Justice Sotomayor and Justice Gorsuch, they concurred in the result. Justice Barrett and Justice Thomas dissented. And Justice Barrett made an interesting point, which I'll bring up here, which I don't think is too off on the tangent. She said, look, if someone is a victim of true threats, we're saying the offender we have to be proven that that is reckless. However, if someone is a private person and they're a victim of defamation or libel, they don't have to show any mental state on the part of the speaker or writer. They can just pursue it. And what Justice Barrett said is she thought that they were basically making up a standard. And what she pointed out is, hey, a victim of defamation or libel, in a way, can be more easily be protected than a victim of true threats. And Justice Barrett said that wasn't consistent with the law, but the 7 other justices disagreed with her, so she did not win the day. So I talked and referenced about these different kinds of mental states or mens rea before, and I think now is a good chance to sort of put them in a definition and give them context. Sort of the most culpable or involved is someone acting purposely in their mental state. And what purposely means is they act purposely when they consciously desire results, such as wanting their words to be received as threats, or sometimes when we're constructing statutes, sometimes the words purposely and intentionally are used interchangeably. I suppose the most sort of black and white example of this would be intentional murder, where the act is whatever mechanism is being used to kill the victim, whether it's a weapon, whether it's an assault, or something like that. But what makes that intentional murder is that when you're doing the act, at least for an instant, a split second, you were intending that person to die as a result of your intent. That would be an example of purposeful. Knowing usually doesn't have much difference from purposefully, but nevertheless, it's a different kind of category. Awareness that a result is certainly certain to follow, such as knowing to a practical certainty that others will take words as threats. In another context, if you were to shoot someone in the head, you might not have been purposely intending to kill them, but you should know that as a result of you shooting someone in the head, that they likely would die or would die. Recklessly, however, is a little bit more distinctive to some degree than purposeful and knowing. And there's more difference between recklessly and knowing and purposefully than there is between purposefully and knowing. Recklessly is consciously disregarding substantial and unjustifiable risk that conduct will cause harm to another, involves insufficient concern with risk rather than awareness of impending harm. So in a threats context, it means that a speaker is aware that others could regard their statements as threatening violence and delivers them anyway. I sort of articulate recklessness as someone where they knew or should have known what was going to happen as a result of their actions. And certainly in the case of Counterman, by making those different kinds of communications, he knew, or you should argue, he should have known that the victim was going to feel scared, that she would feel threatened, that she would feel in fear for her safety. So what is Counterman's impact? Let's break this down. Most jurisdictions aren't impacted by Counterman, and the reason being because most stalking statutes explicitly require the prosecution to show an offender made a communication either with the purpose of threatening a victim, or knowing the victim would feel threatened, or recklessly as to whether the victim would be threatened. Really, Colorado's statute was in a small minority where it didn't require any kind of mental state to be proven. Similarly, the way that the stalking violation in Title 25 is constructed, that's more of the minority model in that it doesn't require a mental state to be proven. Most jurisdictions, I think last time we did a count from our compilation of stalking statutes, at least 40 or so jurisdictions in the United States required some kind of mental state to be proven with a stalking violation. So I'll give you an example of a statute that does require a mental state to be proven, and I'm going to use Minnesota, and this is not because I'm a big, huge Minnesota stan. Look, I'm from Pennsylvania. I just think Minnesota statute puts it pretty succinctly and articulately, and it's a good way to do it. But again, looking at our statutes or our criminal code here and sort of thinking ahead to breaking it down into criminal act and or mental state and or attendant circumstance, like we're in grammar school and we're diagramming our sentences into subject and predicate and direct object and all that. This is what these red hash means. Minnesota stalking statute reads, a person who engages in stalking with respect to a single victim or one or more members of a single household which the defendant knows or has reason to know would cause the victim under the circumstances to feel terrorized, and which does cause this reaction on the part of the victim. And just for reference, if you feel like looking up a Minnesota stalking statute, stalking is a statutory term of art where they talk about course of conduct and repeated acts and things of that nature. So breaking down the parts of Minnesota's stalking statute, the criminal act would be a person who engages in stalking with respect to a single victim or one or more members of a single household. The mental state would be which the actor knows or has reason to know would cause the victim under the circumstances to feel terrorized or to feel bodily harm. So here you have a mental state actually higher than the floor required in Counterman, because what Counterman required was just reckless, and Minnesota has a mental state that's actually knowing. The attendant circumstance would be, and which does cause the reaction on the part of the victim, namely to feel terrorized or to feel bodily harmed. So there might be, some of you might be sort of saying, but hey, wow, Kurland, we love that Title 25 definition of stalking. It doesn't require us to prove mental state. We just have to prove one of those attendant circumstances in that act. That's so easy. Isn't proving an offender's intent or mental state going to be sort of overwhelming or make this too hard? And essentially, this is what's part of what the defense was arguing in Counterman. And it's sort of suggesting that if an offender says the communication isn't meant to threaten someone, does that have to be taken at face value? And the answer is, of course, now, because like most crime, like most any kind of crime, most offenders don't declare their intention or mental state. They don't usually carry a sign saying, I'm doing this intentionally, I'm doing this knowingly, I'm doing this recklessly. And again, I hopefully people here aren't so jaded to be shocked when I say that most offenders, they're trying to conceal their crime or camouflage their crimes. But like anything else, someone's actions can raise inferences about their intentions. Like if I use that extreme example of murder, when you shoot someone in the head, the offender might not be stating, I'm intending to kill you as I shoot you in the head. We can certainly infer what their intention is from their action. And the same thing is true. We can use actions or conduct to infer about intentionality or what someone's mental state was. So what kind of evidence can we use to prove mental state? What kind of evidence do we always use to prove mental state? What kind of evidence do we use in burglaries to prove that someone is intending to commit a crime inside or on someone's property? And we use essentially the totality of the circumstances, the big picture. We don't just look at pieces of the puzzle, we look at the whole picture of the puzzle in many ways, including what they did afterwards. Sometimes an inherent nature of the statement can be used to prove what the intention was. So for something like true threats, if someone says, I'm going to kill you, well, that's pretty good evidence of what they're intending to do. And again, maybe the nature of the statements in a stalking course of conduct isn't going to be as explicit as I'm going to kill you. Maybe it's going to be, you should be so scared of me, you should be frightened. That inherent nature of the statement reveals the intentionality. But a lot of times we can use circumstantial evidence, and there was a lot of evidence of circumstantial evidence in something like Counterman, especially with online communications and other types of communications. Was the offender trying to conceal their identity? Was there efforts to reach a victim through different accounts that was used to communicate? Pretty good effort at showing the intention mens rea is, did an offender ignore requests to stop? If an offender continues communications after a request to stop or desist occurs, that's pretty good evidence that they were making that communication with an intent to cause fear or to cause emotional distress. Stalking usually doesn't happen in a vacuum. There's lots of different kinds of stalking happening concurrently. I think Natalie probably discussed that pretty thoroughly a couple weeks ago. But again, those other methods being used to stalk the victim or to put the victim in fear or to cause emotional distress, it can also inform or help inform the intentionality or the mental state behind a communication. In other words, with their additional evidence, the offender might have been following the victim, surveilling the victim, essentially like that. The other thing, and this is how maybe Counterman framed it as well, is that, hey, look, he wasn't trying to make the victim scared. Counterman wasn't trying to make the aspiring singer or victim scared. He just had a mental illness, or he was mentally unhealthy, that he basically didn't know what he was doing. Well, oftentimes, and again, I'm not trying to appeal to the cynic in any of you, but sometimes, especially in a criminal justice context, sometimes mental illness can be exaggerated or faked, or malingered, I think is the clinical term that we want to utilize here. In those instances where you do find mental illness is being exaggerated or there's malingering, of course, one of the inferences we can draw from that is that an exaggeration of mental illness or malingering mental illness is an attempt to cover up a more negative intentionality, or an intent to cover up being naughty or camouflage being naughty. And so if we have evidence that can expose an exaggerated or malingered mental illness, that's also good evidence of someone's intentionality. So there's my Counterman conversation about it. Let's talk about this in the context of stalking elements. So with stalking elements, of course, you're going to have a course of conduct directed at a person, and there's going to be an impact on that person. And this is essentially how most stalking statutes, including the definition in Title 25, is going to be set up. That course of conduct is essentially going to be a pattern of behavior. In other jurisdictions, that might be how they define course of conduct, as pattern of behavior. And it's going to be at least, I apologize for the typo there, that should say at least, not at least 2 instances required over a certain period of time, evidencing some continuity of purpose. Not every instance of that, or not any instance of that course of conduct, has to be illegal in of itself. But when viewed in a course of conduct, it basically culminates into something that's going to be illegal. But you might have an instance that's illegal, that's legal in an isolated incident, but not legal in the context of the greater course of conduct. There is an option, I suppose, too, that if you have separate incidents, in other words, if you have 6 instances of conduct, you could technically have multiple charges of stalking. Whether or not you want to charge it that way is I leave it to you. I think usually most stalking is just going to be charged as one count or one incident, and then you just put all the different instances of conduct under that charge. But again, sort of going back to what I was talking about at the beginning, that course of conduct and why this can be a great tool from a prosecutorial investigative perspective is that course of conduct is a great way to sort of transform a prosecution or a response to an episode from a narrow lens or some kind of street level view into a broader lens, or go to that satellite or bird's eye view. So in other words, if you have an instance of domestic violence, the offender was assaulting the victim in that case, you have 50% of a stalking case. And you talk to that victim and you find about prior incidents of abuse over a period of time. You find out about instances of meant to sort of exercise power and control over that victim that individually are sort of creepy, but might not be individually criminal, but certainly would be independently intended to cause emotional distress. You take that entire history, that entire sort of course of conduct, and stalking can be a charge that's going to be the thread that ties everything together in one prosecution. So you have an instance that goes from maybe an emergent response to an assault call and can be transformed into sort of highlighting or spotlighting the entire scope of conduct that an offender perpetrated against a particular victim. So the other thing about stalking is stalking only applies to one person. While stalking can affect for multiple victims or multiple people, you want to sort of associate stalking charges with each individual victim. So if you have an offender perpetrating against different victims, maybe against different family members, you would want to have a stalking charge associated with each specific victim, not with each class of people. Sometimes also be looking at online posts. Sometimes they could be so generally stated, it's hard to say whether or not they're directed at a specific person. On the other hand, they might be posted with an intent to definitely, they might be framed in a way to be so general but meant to make a specific person feel scared. But again, context is going to inform that. All right, so the impact involved here with the Title 25 definition, it's going to be causing emotional distress and causing someone to fear for their safety. But that emotional distress is a pretty big umbrella, because lots of things an offender is going to do against a victim can be causing emotional distress. So I do want to note the reasonable person standard. And again, I think Natalie had some conversation about that. But especially if you maybe are speaking to victims where maybe the harassment and the what has happened to them has been sort of normalized against them, you talk to them and it could be that they're minimizing the fear or harm they're suffering. Oh yeah, he left a voicemail message that said he was going to kill me. I mean, he's always doing that. So you might not have a victim that at least on a facial level doesn't appear to be sufficiently articulating that fear of reasonable bodily harm or emotional distress. But again, that victim in some ways has been desensitized to a level that it's not their standard we're using, or that they're not meeting that reasonable person standard. Most reasonable people, if they get a voicemail to that effect, would feel like, oh my gosh, someone left a voicemail threatening that they're going to kill me. I have to take action. And usually even that victim who might be sort of articulating it in a blasé manner, they might really feel harmed. They just don't want to feel vulnerable or lesser. But you might talk to them with the critical follow-up questions. It's like, oh my gosh, I'm sorry to hear that. Is there anything you did differently because of that? Well, yeah, I called you. I called the tribal police, or I took a different way to work, or I changed the security code on my door, or I changed I changed my phone number. If someone is changing something in their life in response, even if they sound kind of blasé about it, then that's evidence in of itself that they were emotionally distressed or feeling harm or learning what was going to happen because of that. So again, that sort of context of finding out, stalking really is a context-informed crime, and it's a crime that really helps us show the wider context of an offender's cycle of perpetration against a particular victim and its effect on victims. Now, stalking by its nature is usually going to be a co-occurring crime, and there's a wide library of crimes that might be accompanying a stalking charge. And again, any one of these crimes here, and I'm not going to break down each of them individually, but conceptually, how I want you to think about it is when you're picking up one crime that an offender perpetrated against a victim, and when there's some kind of pre-existing relationship between that offender and the victim, is that report, in many ways, that disclosure is 50% of a stalking case. And maybe the victim isn't thinking about it in that wider context, but as responders, as investigators, you have the ability and the position to be proactive about it and certainly inquire about other instances to see whether there's the possibility of a stalking charge. So yeah, here's a very sort of sophisticated graphic sort of illustrating the idea of stalking is the idea of an umbrella charge. Is that when you get a stalking case or a stalking charge, is that it is an umbrella for all the other kinds of crimes that an offender may have perpetrated against a victim, and it can help illustrate that. So one of my biggest regrets as a career prosecutor before I joined Aequitas, I had the opportunity to prosecute quite a few domestic violence homicides. And in every one of those instances and in every one of those cases, the homicide wasn't the first instance of abuse or violence that the victim suffered. And when I was less experienced, what I did is I would just sort of look at the homicide and build up the history and find out about the history of the abuse, and I would charge the homicide. And I would be going hand in hand to the judge saying, Judge, can I bring in evidence of these other prior incidents, and begging it. And it's only with experience that, wow, if I charge this homicide with a stalking case or with a stalking charge, I get to almost automatically bring in these prior instances of abuse. So rather than asking permission to bring them in, I'm sort of in the position where, Judge, I'm bringing this in because it's something I need to do to prove my course of conduct element in my stalking case. And it was a lot better way to legitimately and ethically show the big picture of what an offender had perpetrated against a particular victim. So as a charging strategy, articulate stalking, it can certainly sort of highlight or show the lethality risk that an offender might present for a victim, because when you're bringing cases as part of a stalking course of conduct, it's going to be a lot easier for the courts to see or get an appreciation of the full scope of conduct perpetrated by a particular offender against a victim. It's going to be showing that more complete picture of the relationship between the victim and the offender. And it's also going to be, when you can charge that stalking charge, it's going to be helping to explain the victim behavior. It can help give context to why they didn't leave the offender earlier, why they were scared to leave, why they felt like they didn't have another way of support, or maybe even help give context or help explain that why in this given proceeding that they're recanting or minimizing what happened to them. And it's a better way to sort of hold the offender accountable for the full range of criminal conduct. All right. So the last part here, what I'm going to be covering, and again, let me sort of stop here because I'm going to be sort of getting into some maybe investigative particulars, and there's going to be a little bit more overlap with what Natalie talked 2 weeks ago. But I do want to check with I think the 16 or 17 people are here. Are there any sort of questions up to this point? What I talked about with counterman, how stalking charges can be used, anything of that nature? I don't know if you have authority for Mike, but you can certainly throw up any questions in the chat. I haven't seen any, but I want to sort of take a breath and give people a chance to do that. All right. So I don't see anyone jumping to the keyboards. There are two interpretations of that. Either I've explained everything so wonderfully that this is all squared away with all of you and everyone's enlightened and there's no further edification involved, or I did it so confusedly that no one even knows where to begin with a question. So either one of those interpretations is valid. I mean, if I'm optimistic, I'll go with the first one. If I'm feeling pessimistic, I'll go with the second one. But let's talk a little bit about when you have prosecutions understanding stalking behaviors. This overlaps a little bit with what Natalie was talking about last week. And this is by no means the only way to understand stalking behaviors or stalking conduct, but it's a useful analytical tool. And sort of breaking up stalking conduct into whether it's an effort engaged in life invasion, interference with the victim's life, surveillance of the victim's life, or intimidation. And conduct, it doesn't have to fit neatly in one of these buckets. Conduct can be overlapping and sort of simultaneously or be happening concurrently or dovetailing in each of these buckets at the same time. But an example of surveillance, I mean, that's sort of self-defined, but it's the idea of an offender that's going to be following or watching for a victim or waiting for a victim at a location where they're not going to be knowing. This is usually involving the use of tracking software, and it's not just software that's tracking, I should just say tracking technology because of the prevalence of it. Learning information about the victim, including through third hand, as well as proxy stalking, finding out from other people what the victim is doing. Certainly when you have victims and offenders that share custody of children, stalkers who are using the children to find out what's happening with the victim or what the victim is doing is in some ways going to be proxy stalking. Life invasion is going to be that unwanted contact that's occurring. Phone calls that are happening when they're not wanted, property invasion, whether it's going to be damage to property or vandalization, but also just entering the victim's private space or home, publicly humiliating the victim, embarrassing them, and also then sort of harassing the victim through third parties like friends and family. That interference is going to be, could be the identity theft type things, financial work and sabotage, ruining the victim's reputation, preventing the victim from leaving a location or keeping them in either by making them feel unsafe to leave or physically restraining them or preventing them from leaving. And then attacks either on family and friends, as well as a physical or sexual attack. Intimidation could be direct or indirect threats, really. And again, especially I want to sort of refer to intimate partner dynamics too. The threats can be pretty nuanced sometimes. It might not be an explicit, if you do this, this is what's going to happen to you. It can be implicit too, as if you go through with this, what's going to happen with your reputation or our reputation in the community? How are people going to look at the kids? How are you going to have the support necessary? How are you going to be able to stand? Symbolic violence, forced confrontations, and also threats to the victim about harming others. I would also sort of add to this, although it's not enumerated here, a lot of times stalkers might even sort of control the victim too by threatening to harm themselves. Like, I think I'm just going to kill myself, and putting that on the victim, and the sort of fear that the victim would be responsible for that kind of harm that could be caused to the offender. Stalking I think it's going to be pretty rare that you're going to have the domestic violence case that's not also a stalking case, but especially those domestic violence cases that are indicative of a more escalated cycle of domestic violence are almost always going to be stalking. So for instance, if you're going to have a disclosure of strangulation, you have a pretty good suggestion there that, hey, look, when there's a report of strangulation, there's probably going to be prior instances of domestic violence. Reason being is most domestic violence doesn't start with strangulation. Most first dates don't start with strangulation, or there wouldn't be a second date. So to some degree, for an offender to get to the level where strangulation is committed and perpetrated, it had to have been sort of escalated or almost normalized for the victim. So with a little digging or widening of that lens, a lot of times that's going to be strangulation, and stalking is going to be happening a lot of times too. But again, yeah, most domestic violence is going to be happening in the context of an ongoing cycle with prior incidents that aren't just getting on the radar. This is really dangerous because, of course, intimate partner stalkings, they're pretty likely to be threatening. They can escalate their behaviors, use weapons, and physically reapproach the victim. Here's some stats on that. I'm not going to be digging, but I do want to sort of point out here is that, again, if you're using lethality assessments in your jurisdiction, stalking is a lethality risk. So when you get that sort of course of conduct perpetrated against a domestic violence victim, you have a victim that's at greater risk of homicide, of intimate partner homicide, along with these other factors that are sort of articulated here. So I'm pretty sure Natalie mentioned it 2 weeks ago, but one of the tools you can sort of use to assess is the SHARP, Stalking and Harassment Assessment and Risk Profile. Natalie's better qualified to talk about how to administer that, so I'm not really going to break that down in this conversation. Partner stalking in children, victims with children in common with a partner, they're 8.4 more times likely to experience threats of child harm or interference. Because again, most offenders are going to be exploiting a vulnerability that they've perceived in their victim, and children are going to be that vulnerability that an offender can exploit in a victim. Children in common also increased a likelihood of a child being used as a tool to harass and stalk a victim as well. So I do want to sort of reference a little bit with intimate partner violence and technology. I'm going to discuss this a little bit more later. But of course, when you have an intimate partner violence dynamic, boyfriend, girlfriend, husband, wife, or partners effectively, I want you to sort of appreciate too that there's a lot more access points for that technology to be used by an offender, because often that offender, that stalker, is going to have access to that victim's digital life. And think about it, even maybe in your own life. I mean, hopefully everyone here is in a healthier relationship as you ever hoped. And for those of you who have partners, think about how much of your digital life is shared with your partner. How often do they know the passwords you use? How often are you on Find My Friends or whatever the Android equivalent is? Because this is sort of one of the nature of intimate partner dynamics. Now, this isn't true for every intimate partner dynamic, but it's not uncommon. But in an unhealthy intimate partner dynamic, especially a violent one, this is something that can be used to coerce and to control a victim by an offender. And think of the things you use for passwords that your offender might know: your birth date, the street you grew up on, the name of your childhood pet, mother's maiden name. All the things that are typically used as computer screen or security screens is something that a lot of offenders in an intimate partner dynamic are going to be familiar with from their victims. The other thing to sort of be alert of too, and why those lethality assessments can be so useful, because a lot of times perpetrators are going to be sort of trying to cloak themselves as their victim. They can even manufacture evidence to make them appear as as a victim of stalking. This is a lot easier to do with technology. I know anyone who's sort of tracking the development of AI and deep fakes and stuff like that can appreciate maybe how easily it can be abused, which is of course why we want to sort of dig deeper and always be looking into the stuff. So stalking and sexual violence, how can that manifest? Of course, sexual violence, it can also be when there's a pre-existing relationship, such thing as sharing sexual photos or videos with others, maybe damaging access to contraception and that sort of a pattern of behavior, telling the victim's intimate partner about sexual assault, and it won't be framed as a sexual assault, but hey, look, that they cheated or something like that. Things of that nature. Monitoring victim, and so you can know when there's an opportunity to perpetrate sexual assault, gathering information about them, non-consensually watching the victim, filming them, leaving gifts as a way to make them feel scared, spreading rumors about the victim, or impersonating the victim online to discuss or share. So those are all ways. So generally, what I want to emphasize too is why you want to name stalking or always charge it in the prosecution is because it's going to be critical for safety planning. And the reason why it's critical for safety planning is that when we charge stalking, there's a clear picture of the scope of an offender's conduct against a particular victim, and it's more exposed. So then the reality of the risk by an offender to a particular victim can be more readily identified. And it also gives victims empowerment. And it gives victims empowerment by not showing what happened to them in a sort of isolated still photo, but also the greater context of what unraveled. All right. One thing, though, to be careful and talked about is, and again, when we're talking to victims and sort of recommend disengagement, when that can happen, especially when they're being sort of targeted digitally or electronically, that's great. But we also want to remember that most offenders aren't going to stop just because they've been told to stop targeting the victims. We want to realize that victims are going to be engaging in behaviors to keep themselves safe. Just like our offender probably knows our victim better than anyone else, our victims are likely to know the offender really well too, and what's going to stop the offender. And one thing about if the victim knows how an offender is having contact with them, so for instance, say the victim knows the offender is tracking them through a phone. A lot of victims might sort of accept that because, well, wow, at least now I know what he's doing. Whereas if I get rid of my phone or the tracking device and they can no longer track me, then I don't know what the offender is going to do. So a lot of times letting that offender sort of keep in contact or contacting the offender can, for many victims, be a way to sort of try to manage the offender, to take that offender's temperature. So I sort of wrapping up here, I'm not going to get into as big a conversation about digital evidence, but I do want to sort of stress, because digital evidence does have such an intersection with stalking, is to always be looking for ways we can respect and prioritize victim privacy in our digital investigations. And so what this means is that when you have some of this course of conduct in a stalking case perpetrated against a victim through electronic evidence, try to minimize seizing a victim's cell phone or social media accounts. Now, obviously, you're going to want to be preserving evidence relative to the case from those sources, but ask yourself or look presumptively to do that through methods of screenshots and screen recordings. And the reason why is because these kinds of devices, so much of our modern life depends on those, and compromising or exposing the victim's privacy interests or privacy rights in those things can sort of chill their ability to be able to participate in an investigation and a prosecution, and is really not in the best interest of a prosecution or investigation in the long run. Also, we do want to sort of consider too, when we find electronic evidence related to the victim, maybe intimate photos or something that don't relate to our investigation, we want to be looking to redact those Now, let the defense know about the redaction, offer to conduct additional searches, but we shouldn't just presumptively be handing those over. So the privacy implications of of our digital lives, and specifically our cell phones, it's been recognized in Supreme Court case law. They've recognized several interrelated privacy consequences, massive amounts of storage. So what this means, of course, is that we want to sort of minimize seizing the victim's devices as much as possible and looking for other methods to preserve that evidence. So I will sort of reference one case here that sort of illustrates the how not seizing that evidence can make us better positioned in litigation to protect a victim's privacy. This is from a Minnesota Supreme Court case, and again, I'm not a Minnesota stan, but both their stalking statutes in this case coincidentally happen to be from Minnesota. There, the trial court was reversed for ordering a victim to turn over the cell phone to a defense forensic expert. And what they found is that the victim didn't waive the right to her privacy in her phone by disclosing sexual assault and allowing prosecution to copy a limited portion of their phone. So what had happened there is that the victim had kept their phone. The defense had asked for an order for the victim to produce her phone to a defense forensic examiner. The trial court granted that. The prosecution took an appeal, and the trial court was reversed. And the Minnesota Supreme Court recognized, as per Riley, that there are privacy concerns with electronic devices, and courts should carefully examine motions for such data, particularly for a sexual assault victim, that basically by disclosing and reporting a sexual assault, and when the government didn't already have the evidence in their possession, which they didn't because the victim kept possession, it didn't become open season on the victim's digital life necessarily. All right. So I did skip a couple slides just because I think I was sort of going out of context. Going forward, what I want to urge people to do, and it looks like we'll be able to end a little bit early, in the event there's not any questions, recognize the prevalence and scope of stalking behaviors, identify the elements of stalking statutes, and analyze cases in relation to those elements, charge stalking along with any applicable co-occurring crimes, and collaborate to hold offenders accountable and promote victim safety and privacy. So here's my contact information. I understand you're going to be getting a copy of these slides after the presentation. So I'm not going to belabor that. I do want to emphasize, though, if you want to take a deeper dive into some of these subjects, Aequitas and SPARC have a variety of resources that are attached here, which I'm not going to entirely unpack. I just sort of want to give you a taste of them. And I'll go back to my contact slide, and I just want to find out if there's any questions on any of the topics we discussed or generally about stalking. All right, Chia, I think that that'll take me to the end, if it's okay if I end 8 minutes early. Of course, now I'm putting you in the position of a villain.
That's
You have
fine.
to stay till the extra 8 minutes.
No, thank you. Appreciate your time, John. It's very helpful. And again, as he mentioned, I will send the slides out to everyone, and we have the recording, and we'll send the recording as well. And Marlon is going to drop into the chat just a very quick evaluation. I think it's like 1 minute, and I'll send that out as well. So if you all could please fill that out, and then thank you again, John. We really appreciate this information, and it's been really helpful. So if anyone has questions, you can contact me or contact John here on his contact information. So with that, I'd like to thank everyone for joining, and have a great rest of your day, everybody.